Welcome to this AP video lecture on the Supreme Court. Now, I gotta say, I'm pretty excited about this. And here's why I love talking about the Supreme Court. Supreme Court is one of those institutions that's not that well understood, but it's really powerful. The Supreme Court got started basically with the third article of the Constitution, right? So you would think it was really clear on what the Supreme Court was supposed to do. Actually, it's not. If you read through the third article, it kind of leaves it up in the air. All we're left with is that the Supreme Court is supposed to handle cases that deal with people from this country and another country, or maybe people between states, and that's about it. You want to know how exciting the Supreme Court was at its beginning? Its very first case was West v. Barnes. You know what that case was about? A farmer who owed debt. Yeah, that was about it. So what ended up happening was this. The Federal Judiciary Act of 1789 established how many justices were going to be on the court. Guess how many? Just 6. Now, I know you're like, what does that matter, right? Well, today there are 9 justices on the court. In its history, it's had 5 at the least, and it's had 10 at the most. The point is, it was never really clear what the Supreme Court was supposed to be about or what it was supposed to do. But the Supreme Court is really powerful. Why is that the case? Well, Supreme Court justices are nominated by a president. They then have to be confirmed by the Senate. And then that Supreme Court justice is on the court for life. They're basically there until they retire or they die. That means they have power long beyond when they're initially put onto the court. So what do these guys actually do? Okay, so most Americans tend to think that the Supreme Court, basically all it does is it just takes out the Constitution and they just read it, right? Not at all. In fact, what Supreme Court justices do is they interpret the Constitution and then they provide that information to people. Now, they have 2 different ways of doing this. One is called strict construction. Strict construction means that we read the Constitution as literally as possible and apply it based upon what the original founders of the Constitution thought. Why do this? Well, actually, there's a pretty good reason. The idea is this. There are only 6, or today, 9 Supreme Court justices, right? Imagine if they made laws for everybody in the country. Well, that would kind of suck. That means that we don't have really a democracy. We have these elite groups of people making these decisions. So the idea of strict construction is that Supreme Court justices should determine what the Constitution says and then follow it to protect democracy. Okay, so that's our first way of interpreting. What's the other way? The other way is what's called loose construction. Loose construction means that the Supreme Court interprets the Constitution and applies it as best as they can in the circumstances that they're holding. What does that mean? Well, here's the idea. First of all, the Constitution can be kind of vague. In some cases, like when it argues about free speech, well, what does free speech mean? And when should we apply it? Well, according to people who believe in loose construction, the idea is Supreme Court justices, they got to figure that out. They've got to interpret that. And the whole notion that they should go by what the original founders thought doesn't make a lot of sense. The original founders lived 200 years ago. They were farmers in a farming republic. And let's be honest, they didn't always do things that by today's standards would be all that great. So maybe what we need to do is update the Constitution with our interpretations to protect people's rights. In other words, to protect democracy. Now, you're probably noticing something, right? Both systems claim to protect democracy. They just have different methods of how to get there. Okay, so how much power does the Supreme Court really have? Well, have you ever been to the Supreme Court? The Supreme Court building is right across the street from where Capitol Hill is. That's the congressional building. If you ever go there, it's almost like you're entering into a Greek temple. Basically, you have to walk up these huge steps. And at the very top, there are these huge doors that are in bronze. And there's these huge Greek-style pillars. Now, those bronze doors, nobody ever goes in them. Where you actually go is around the corner. You go in through a small door. So why do we have it like this? Because you feel like you're entering into a Greek temple. And when you go in, the Supreme Court justices, they don't sit on the same level as everybody else. They come in and sit above everybody else. They wear long black robes. And on top of that, they tend to be old. Why do they do all this? Because psychologically, we get the sense that Supreme Court justices are like the priests of our democracy. They're the smart guys who make all the right decisions. Well, the truth is sometimes their decisions haven't been all that great. And on top of that, sometimes their decisions really reflect their own desire for power. Okay, we're going to take a look at two cases that demonstrate what I'm talking about. So the first Chief Justice who's important is a man named John Marshall. And John Marshall didn't become Chief Justice until 1801. He was about the fourth Chief Justice, but he's really important. I'm going to give you just two of the cases that he went up against that demonstrate this. The first is something called Gibbons v. Ogden. Gibbons v. Ogden took place in 1808. Here's what happened. New York had given a monopoly of the seas, basically between New York and New Jersey. And the guys they gave that to was Aaron Ogden, who owned a steamboat business. Well, along came this guy named Thomas Gibbons, and Thomas Gibbons said, no, Congress gave me a monopoly of that area, and I'm the one who deserves it. Okay, fine. What does the Constitution say? Well, here's what the Constitution actually says in Article 1, Section 8. The Constitution gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So you'll notice right there, John Marshall, he made his decision. His decision was Congress was right. And then because of that, Thomas Gibbons was the one that really ended up getting the monopoly. Now, there we have strict construction, right? Goes along nicely with what John Marshall was saying. But let's think about that for just a second. What's the context of John Marshall? John Marshall is a Federalist. John Marshall believes that Congress should have a lot of power. So this nicely aligns with his belief system. Now let's go to the second case. I want to give you a little bit of context of this. In the year 1800, the Democratic Republicans demolished the Federalists in the election of 1800. Basically, what ended up happening was President Thomas Jefferson became president, Democratic Republican, and the Congress became Democratic Republican. At that point, the only institution left that was Federalist was John Marshall's Supreme Court. Well, in 1801, a case came before him called Marbury versus Madison. Here's what happened. Right before John Adams, the president before Thomas Jefferson, was thrown out of office in the election, he decided that he was going to create a whole bunch of new courts right below the Supreme Court, what are called circuit courts, and pack them with Federalists. Well, just before the inauguration of 1800, he wasn't able to get out all the invitations to all the justices he had put into those courts. One of them was a man named William Marbury. William Marbury found out about this and he said, hey, this position belongs to me. I just never got the invitation for it. Well, the guy who was Secretary of State, James Madison, had said, we're not sending you out that invitation because, hey, we're a whole new administration, right? So Marbury said, fine, I'm going to take it to court. And when he did, he thought for sure he would end up winning in this case because, hey, he's a Federalist. John Marshall is a Federalist. Well, John Marshall was in an interesting situation. If John Marshall sided on the side of Marbury, it would be obvious to everybody he was doing this because he was a Federalist. Nobody would take it seriously. But here's what John Marshall did. It was pretty brilliant. He said, you know something, William Marbury? Do you deserve your position? Yeah, you actually do. You know something else? Should James Madison send you out that invitation? Yeah, he should. But who was the one who had to force them to do that? The courts. The courts were the one that had to do that. He said, you know something? The Constitution never gave the courts the right to do something like this. So it's unconstitutional for me, John Marshall, to force Madison to send you that invitation. Okay, doesn't sound like that big of a deal, right? Notice what John Marshall just did. He said, I agree with you, Marbury. You should get your position. I know Thomas Jefferson would react pretty badly to this. So I'll tell you what I'm going to do. What I'm actually going to do is I'm going to give myself a whole new power. The power I'm going to give the Supreme Court is what's called judicial review, the ability to determine if a law is constitutional or not. This is nowhere in the Constitution. This is not strict construction, it's loose construction, and it fits nicely into John Marshall's Federalist beliefs. He just strengthened the Supreme Court, the federal most important judicial group in the country. Remember how boring the Supreme Court was at its beginnings? Well, now it has a whole new power. The power that it has now is to determine if laws passed are constitutional. That means whether it's a Democratic, Republican, or a Federalist, the Supreme Court can determine if they can really get anything done. Pretty smart, huh? Okay, see you in class.